So again, thank you so much for this invitation and letting me introduce this very inspiring conference. As you know, Pasquale, Philip, and some of you, including myself, are working on a project of the International Law Association. Now comes my second slide. Yes, of the International Law Association, and we are trying to bring together again public international lawyers and tax experts. And during the first stage of our research, we were working on taxpayers' rights, and I think we have already produced an impressive
Juliane?
Yeah, we are coming to the second phase of our study within the International Law Association. The first was on taxpayers' rights, the second is on nexus and fair distribution of international taxing rights. And so this conference is a perfect kick-up for the second stage of our research. The third stage will be on the implementation of international tax law, and we deal, for example, with mutual agreement procedures and with arbitration. But now on nexus. Rethinking nexus is part of adapting taxation to new challenges, including anti-tax avoidance by large companies operating worldwide. This is not surprising that we have to rethink nexus, because the currently still valid concepts were established by 100 years ago in the 1920s. At that time, experts of public international law were establishing and defining those concepts. Today, everybody agrees that the concepts have to be adapted to new circumstances, also to effectively regulate the worldwide market, and to distribute revenues from worldwide income fairly between the nations. To my opinion, it's important that we as scholars contribute to this process. This increases the chance that the new concepts will be coherent and then valid for another 100 years. Therefore, again, Eduardo, thank you for organizing this conference. And now it's a challenge for me to introduce the conference before knowing what you all will have to say on Nexus from the different perspectives. So let me just make some introductory remarks on Nexus and its different requirements depending on the type of jurisdiction and the type of tax, and then on Nexus in a changing world. Now comes slide 3. Nexus is a means to delimit the jurisdiction of the states. Requiring nexus helps to prevent that every state exercises its jurisdiction everywhere. Theoretically, the jurisdiction of states could be universal and only limited by the jurisdiction of other states. However, the prevailing opinion now is that states do only have jurisdiction to prescribe, to legislate, and to enforce their rules with regard to persons and events to which they have a sufficient link. Now comes slide 4. The requirements for affirming such link depend on the type of jurisdiction in question. The closest link is necessary where a state takes enforcement measures in another state, a lesser link is sufficient as a basis for the jurisdiction to prescribe, or where the courts of one state adjudicate cases or events that took place in another state. That's logical and makes sense. Taking enforcement measures in other states interferes much more with the sovereignty of those other states than making laws or judgments which are supposed to apply in those other states. The American Law Institute's restatement of the law 4th provides for quote, jurisdiction to enforce in the territory of other states only with the consent of those other states. It is indeed generally recognized that each state has a monopoly on the exercise of governmental powers within its borders, and no state may perform an act in the territory of a foreign state without consent. Even within the European Union, agreement between the member states remains the basis for foreign tax officials' participation in joint audits, and those foreign tax officials can in principle not take enforcement measures. Therefore, finding a sufficient link, a sufficient nexus for taxing foreign residents abroad on the basis of a significant digital presence or the marketplace principle, jurisdiction to prescribe, does not mean that revenue can effectively be collected, jurisdiction to enforce in other states. To obtain the tax revenue rather needs consent and cooperation of the states where the taxpayers or the assets are located. But what is now meant by enforcement in the tax context? Does, for example, the sending of correspondence for the purpose of enforcing revenue laws amount to enforcement jurisdiction? Enforcement jurisdiction occurs immediately after jurisdiction to prescribe ends. There should be no gap in between. So is correspondence prescription or enforcement jurisdiction? Insofar, a distinction should be drawn between documents of notice that merely involve the supply of information with no threat of penalties in the event of non-compliance, from documents involving a compulsory process or containing a command. The latter category is enforcement jurisdiction. Because the power to tax is a sovereign power, steps taken to give effect to that power in the territory of another state is enforcement jurisdiction. As Philip Baker has set forth, there are also different nexus for direct and indirect, particularly consumption taxes. It seems reasonable that consumption taxes are to be paid at the place of consumption. The situation is more difficult with regard to income taxes. The residence and the source principle apply. For legal persons, as also suggested by Philip, the source principle makes more sense than the resident principle, taxing the worldwide income of a company only because it was incorporated or registered in a certain state, for example, Nebraska. Incorporation theory, or finding out where its effective management sits, seat theory, is not evident. On the other hand, it's becoming also more and more difficult to determine the territorial source of income, the state in whose territory the value is created in the digitalized economy, as opposed to the brick and mortar economy. So we are facing some difficulties with regard to determining the nexus, especially for income tax. VAT, transaction and sales taxes lie somewhat in between consumption taxes, easier nexus. Consumption will always be material, substantial and not digital, and income taxes, more difficult nexus. With regard to sales tax, as you all know, there has been interesting development in the United States, reflecting the changes in the economy, the US Supreme Court reversed its jurisdiction until 2018. They were not allowed to charge sales tax on sellers who did not have a physical presence as nexus in the state, such as companies doing a mail order, online shopping, and home shopping by phone. Therefore, increase of remote selling as now in times of Corona led to erosion of the sales tax base and corresponding loss of critical funding for the state and local services. Against that background, the Supreme Court, in its famous Wayfair decision of 2018, reversed the
You're muted.
Juliane, we can't hear you.
You're muted.
when did you hear me?
Yeah.
I can't see you, so
It's
yeah.
okay. Now we can.
Yeah,
hear
but
you.
I have no idea when you lost me. You must really cry then.
It was
Wait.
one.
Wayfair.
Right at Wayfair.
Wayfair. I don't know when Wayfair. Okay, Wayfair. Well, I just said that in 2018 there was this remarkable reversal of the jurisdiction, and the Supreme Court explicitly gave up the requirement of physical presence, and it even called the former requirement of physical presence an original error, which becomes all the more egregious and harmful in the present realities of the international marketplace. Moreover, as you know, the physical presence rule is neither clear nor easy to apply, as attempts to apply it to online retail sellers have proved unworkable. And this physical presence requirement had led to serious inequity and the issue of tax erosion. Thus, the Supreme Court openly reversed its case law, allowing now marketplace jurisdiction without the taxpayer's physical presence. Each year, physical presence becomes further removed from economic reality and results in significant revenue loss to the states. The Supreme Court said, of course, different types of taxes require different types of nexus. That's true. Nevertheless, I think that decision is further evidence of the development towards a broad concept of territoriality, or, depending on the terminology, even of a tendency towards extraterritoriality. And that tendency is not restricted to sales tax, not even to indirect taxes, not even restricted to taxes at all, as will be shown. Now, slide 5. I will talk on nexus in the changing world. First, territoriality and extraterritoriality. The principle of territoriality has been the most basic principle of jurisdiction in international law. There is even a constitutional presumption against the extraterritorial effects of legislation in several countries. The principle of territoriality is also at the basis of the ECJ's recognition of exit taxation. The court has held, quote, that in accordance with the principle of fiscal territoriality linked to a temporal component, namely the taxpayer's residence for tax purposes within its territory, with the national territory, during the period in which the capital gains arise, a member state is entitled to charge tax on those gains at the time when the taxpayer leaves the country. The same is true with regard to the concept of abuse or CFC taxation, which depends on wholly artificial arrangements without genuine link to the territory. Taxpayers cannot choose a tax jurisdiction to which they do not have a genuine link in order to escape taxation in a state who exercises its tax jurisdiction on the basis of such link. However, a development towards that broad understanding of territoriality or towards extraterritoriality or marketplace jurisdiction can now be found in all areas of the law, starting with competition law, where the so-called effects theory is firmly established. Accordingly, states may regulate behavior outside their territory, but which has effects on their territory. Extraterritorial jurisdiction is also an issue becoming more and more important. For example, in data protection law, think of the recent privacy shield judgment of the ECJ, in intellectual property law, and also in human rights law, think of those supply chain acts in many countries, Lieferkettengesetze. And for example, the US Supreme Court is currently deciding whether American corporations can be sued in the US for alleged human rights abuses occurring abroad. Cargill Incorporation and a subsidiary of Nestlé are accused of knowingly helping perpetuate slavery at Ivory Coast, Cocoa Farms. Thus,
Attends, il y a un souci là. Windows Defender Firewall. Okay.
Do you hear me?
Je fais no.
Could you mute your microphone? Not you, Juliane, but all participants, please.
It's really difficult at the court with and I was muted. Sometimes I'm muted automatically. So thus, can you hear and see me?
Yes.
Okay. Thus, territoriality in the narrower sense is the most important, but not the only genuine link. Either further links have to be recognized, or territoriality has to be defined very broadly. The latter broad definition of territoriality seems to be the approach of the European Union. Thus, the explanatory memorandum on the proposal for a Council directive implementing enhanced cooperation in the area of a financial transaction tax says,
I would let you use the computer like this on battery and Wi-Fi for the meetings.
Okay.
Says this memo on the FTT tax says that it is ensured that taxation can only take place in the presence of a sufficient link between the transaction and the territory of the FTT jurisdiction. As in existing EU legislation, the memo goes on in the area of indirect taxes, territoriality principles are fully respected. However, this full respect of territoriality by the FTT proposal is controversial and only true when applying a very broad understanding of the principle of territoriality. Article 4 of the FTT proposal defines established in the territory of a participating member state broadly. Accordingly, authorization or a permanent address is sufficient inter alia. The reference to a financial institution authorized by a member state covers, for example, authorizations by the member state concerned in regard to transactions operated by a third country financial institutions without a physical presence in the territory of the member state. However, the person liable for paying the FTT may prove that there is no link between the economic substance of the transaction and the territory of any participating member state. The residence principle and the FTT proposal is further supplemented by the issuance principle.
So it's good to know that we know now that there is actually a network issue. It's not the problem of the computer.
Is supplemented by the issuance principle as a last resort in order to improve the resilience of the system against relocation. This is meant as a measure to further strengthen anti-avoidance of taxation. Accordingly, financial institutions outside the EU would also have to pay FTT when trading with financial instruments issued originally within the EU. Now on the hybrid constructs. The appearance of new hybrid taxes is further evidence of the tendency towards marketplace jurisdiction. Several countries, as well as the European Union, are now adopting or planning to adopt income taxes with features normally found with
We cannot hear you, Juliane.
Two proposals. I'm talking about the hybrid construct, member states and the European Union. The European Union has proposed those two directives, the one on the significant digital presence and the other one on the common system of a digital service tax on revenues resulting from the provision of certain digital services, while the first proposal regarding taxation on the basis of a significant digital presence is based on the harmonization competence for direct taxes, Article 115 TFEU. The second proposal on the services tax is based on Article 113 TFEU, the Union's competence to adopt provisions for the harmonization of legislation concerning turnover taxes, excise duties, and other forms of indirect taxes. But this is not evident. It is not evident that the proposed digital services tax is an indirect tax. The turnover-based tax is not necessarily an indirect tax. Such hybrid taxes are becoming common also in member states of the EU and elsewhere. For example, Poland and Hungary have adopted turnover-based taxes which are progressive. That means taxpayers with higher turnover pay more independently of their net income. The Hungarian turnover-based tax on advertisements taxes advertisements emitted wherever in the Hungarian language. The ECJ did not object to language as a sufficient link for Hungary's jurisdiction to tax. The EU Commission, however, maintains that such taxes are impermissible state aid. State aids to undertakings with lower turnovers and thus violations of the principle of state aid, favoring certain, that is, smaller undertakings. The Commission maintains that tax progression can only apply in the field of income taxation of natural persons, but neither to taxes based on turnover nor to corporations or legal persons. Nevertheless, the concerns and reasons of the US Supreme Court shifting to marketplace jurisdiction also underline the EU Commission's proposal for corporate taxation on the basis of a significant digital presence in similar national legislation. Indeed, it is not clear why a single employee or a single warehouse should create a substantial nexus, while physical aspects of modern technology should not. A virtual showroom can show far more inventory in far more detail and with greater opportunities for consumer and seller interaction that might be possible for local stores. So without any doubt, the continuous and pervasive virtual presence of retailers creates a substantial virtual link for marketplace jurisdiction. But is this reasonable and fair? Nexus concerns the delimitation of competences and spheres of influence and power between the states. However, in tax law, it is even more. In tax law, nexus also stands for delimitation of the taxing powers and thereby for the distribution of tax money between the states. The residence and source principle is nexus for the delimitation of taxing powers was reasonable and easier to handle when they were developed 100 years ago. At present, however, the discussions and legislation all around the globe reflect that those rules do not fit anymore, do not correspond anymore to fair and reasonable distribution of world income. And those traditional rules also facilitate tax avoidance by multinationals. There are indeed some valid arguments now for marketplace jurisdiction. Consumption presupposes solvent state and local governments. States fund the police that protects homes where consume is possible and ensure that goods are safely delivered, public roads, services, digital services, support the banking system and the courts to ensure collection of the purchase price and create the necessary climate of consumer confidence. Moreover, the country of consumption remains with the waste going along with consumption, first packaging waste, and then to dispose of often short-lived consumer goods. As in competition law, a state has jurisdiction to make rules regarding acts taking place in other states as the production of goods and services, but which do have effects within its territory. And there can be those extraterritorial effects. It also appears that the more recent trends to extraterritorial jurisdiction are mainly directed against large companies operating worldwide. Some national legislation therefore applies progressive tax rates. Other EU and national legislation only apply to companies surpassing a certain sales or turnover threshold or having more than a certain number of employees. Again, such trend to treat small enterprises differently is not restricted to tax law, but also present in, for example, competition and human rights law. Common to such legislation is the concern to take into consideration the small businesses, startups, and others who engage in commerce across state lines, while at the same time trying to effectively regulate also larger companies. The Commission proposals therefore require a significant digital presence with threshold figures of worldwide income of 750 million and
You're muted.
I do not mute myself. That's wanted just to clarify that. Yeah, thank you. Interestingly, the Commission invokes discrimination of big enterprises against similar national taxes, which also have thresholds, and vice versa. The same critique comes from inside member states against the Commission proposal. According to such critique, a tax that applies only to large companies violates the principle of equal treatment, fundamental freedoms, and classifies as prohibited state aid in favor of small companies. So the question remains, is it legal and fair, or is it unfair or illegal to treat small and big companies differently? Those cases, the Hungarian and the Polish case, are still pending before the court. In any way, such critique can only be understood due to the hybrid character of such taxes. Tax exemption below a certain threshold, as well as progressive taxation according to the principle of ability to pay, are common features of income taxation. In some countries, taxation in accordance with the principle of ability to pay is even constitutionally required, and a few countries even require progressive taxation. So what are the remaining problems and what to conclude? The concept of significant digital presence underlying recent EU and national legislation doubtlessly fulfills the condition of sufficient link or nexus as a basis for exercising tax jurisdiction to prescribe under public international law. However, the proposed solutions are by far not perfect. The new hybrid taxes easily lead to double taxation in the country where the services and goods are consumed and in the country of residence of the producer, a problem still to be solved, but probably not unsolvable. Such new taxes thus need to be integrated into the new system of direct taxation of income by the resident country and VAT or sales tax in the countries of consumption in order to avoid undesirable multi-taxation. Even though neither public law nor EU law prohibit double taxation, it is unwanted. Also, it's generally a burden on taxpayers to file tax returns and pay taxes in states other than their residence state, and even more so for persons and companies selling goods and services in a multitude of foreign countries, and even more so for small companies. On the other hand, tax exemption below certain minimum thresholds may lead to arbitrary results and invite to circumventing those thresholds by artificially splitting up companies. Another problem to be solved. Moreover, turnover-based progression is not in line with the net principle. It may affect the substance and not only the profits of a company. Thus, hybrid taxes, as the proposed EU taxes on the basis of a significant digital presence and the digital services tax, as well as national progressive taxes based on turnover, have been criticized for breaking with the existing principles of the international tax law system. Nevertheless, there are strong reasons for further developing the principles of the international tax law system. I think there are reasons for a greater share of the marketplace jurisdictions. With regard to the Commission proposal, it has to be said the marketplace jurisdiction is the European Union. With regard to many other taxes, however, the marketplace jurisdictions can be in developing countries, but this could possibly be fair. We will hear more about all those questions in the contributions which follow. Thank you very much for your attention.